Right now. Hi, my name's Brad Hunter, and I'm a Regina area family law lawyer, collaborative lawyer, and mediator. And I'm with Charmaine Panko, who will introduce herself in a second, to discuss the collaborative law participation agreement, which is something which is near and dear to the hearts of both of us. Charmaine.
Hi, I'm Charmaine Panko. I'm a collaboratively trained lawyer and mediator based out of Saskatoon. And Brad and I work together in the specialized process that we've labeled concierge collaborative process because it is all about working together in a way that is going to assist parties in their reconfiguration of their family system to accomplish their short-term and their long-term goals in a collaborative fashion. So, Brad, would you like to share your screen so we can kind of show everybody how the contract is set up, which creates the foundation of the work that we do together?
And Charmaine, can I point out as well, we're in a new era in Saskatchewan where your first step in any case, in any divorce, if you're not able to settle yourself, is to use alternative measures, alternative ways of dealing with separation. One of them is mediation, one of them is arbitration, but one of them is collaborative practice, collaborative law. And this really is a new era where this is first choice for people. And it's something that should be looked at very carefully. So I prepared this document, this participation agreement. Charmaine, is this a standard agreement that all Saskatchewan lawyers use or use something very close to this?
Yes, it's one of the values to being part of a group of like-minded professionals. So the lawyers that are collaboratively trained, but also the family professionals and the financial neutrals, is that we do want to deliver a similar experience across the province with all of the collaborative files. So though you may find a collaborative contract that has some adjustments of based like to represent the unique needs of the family, this does represent a pretty basic contract that everybody would use.
And it's been used across North America and the world. There are very close versions of this for at least 30 years,
Mhm.
and it's shown a lot of success. So let's go through the agreement. And I'll just start with our goals and we'll just kind of go back and forth and talk about them. So this is what we'll do at the
Sure.
start of a collaborative meeting, is we'll go through the contract and we will talk about it and make sure everyone understands it. So our goals are to resolve the differences between the spouses through interest-based negotiation. We'll talk a little bit more about that using the collaborative process. And the goals are for them to reach, in this case, Jane and Robert, to reach a mutually acceptable agreement and to have a binding contract. And the third goal is to ensure that each person has legal representation, so they're properly represented. And that the last goal is to get the people we need at the table. So sometimes as lawyers, we can work things out or help people work out their arrangements. But in many, many cases, it's really important to have other people participate. So let's go to the second part of the contract, which is the essence of the process. And Charmaine, why don't you discuss that?
Yeah, so unlike other models that might involve letter writing back and forth between people who never see each other, the collaborative process is based on negotiations that occur in face-to-face meetings. And when we can't meet in person, we can still meet face-to-face using a virtual meeting format. All, the lawyers and any other professionals that are retained will assist the parties in coming up with mutually acceptable solutions. So once again, it's not about what does Jane want and what does Robert want and the two of them duking it out. It's about helping them come to a resolution that they are both satisfied with. Ultimately, though, Jane and Robert are the ones who are responsible for the decisions they make. So we really honor parties' right to self-determination. This isn't about what Brad and Charmaine think is the right outcome. It's what Jane and Robert want. Now, if something was to happen that Jane and Robert weren't able to finalize their matters through the collaborative process, Brad and I would be disqualified from representing them in any kind of formal adversarial format like court or arbitration. And instead of focusing about the what would that look like if the parties decided to duke it out rather than work together, we are going to be committed through this contract by agreeing to, and there's a big list here of really important mindset principles here. We're going to deal with each other in good faith. We will be respectful, constructive, and timely in all our communications, express our interests, our needs, goals, and proposals, and seek to understand those of the other, provide full and honest disclosure of all information and documents, be willing to compromise. If there are agreements reached sort of from time to time during the process, we'll comply with them. There's some certainty that's necessary where we say nobody's going to unilaterally make a change to the way things currently are until things are resolved through the process.
If I can jump
Maintaining
in briefly,
confidentiality.
one of the first things we do is to stabilize the situation, because often, especially just after the separation of a couple, or even when they're living together, the situation's pretty dynamic, and we work to kind of stabilize that to give them a chance to move on. Go ahead, Charmaine. Sorry to interrupt.
Yeah, no, that's a great point because the certainty that comes with having some consistency and stability, it's in all the areas, whether that's related to parenting, finances, or property. And I think that I mentioned about the confidentiality, which is another really important feature to the process. It's kind of like you're operating within a bubble. So the conversations that we are having, the four of us and any other team members remain within that bubble. We also will encourage you as the party, so in this case, Jane and Robert, to not discuss matters outside of the process without mutual agreement. So that doesn't mean that they can't talk to each other, of course, Brad, but it does mean that we want to assist them. And sometimes people fall into their unhealthy communication patterns. We will correct and not take advantage of any mistakes. And that's really directed not just at the parties, Jane and Robert, but also between you and I, Brad, because
Mhm.
if I was to make a mistake, then you would be bringing that to my attention rather than trying to take advantage. Isn't that right?
That's correct, and it's just part of good faith because people will find out if something was mistaken. It could be everything from not understanding something to even making something simple as an addition mistake or a math error. And
Exactly.
it's part of what you do if you're trying to reach an agreement.
Absolutely. We're going to work together to develop an array of options for settlement and use best efforts to come up with something that will be mutually acceptable. Now, there's an additional document that we'll take a look at a little bit later here in this video. It's called Guidelines for the Clients During the Collaborative Process. And it's just some basic communication guidelines and principles. And so that's one of the commitments here in this contract is to adhere to those principles. And then the last bullet point here is about maintaining our focus in this process means that we're not going to try to leverage a threat or bully somebody to say, well, if you don't agree to something, then I'm just going to have to take you to court because that is really not congruent with the essence and the focus of our process.
So, and if I can just point out a couple of points that I think are important in there, the one of them is the fact that what the law says is important to people when they make decisions, but that's where the threat of court may come in. It's legitimate to look at what a court or a judge might do, but the threat is kind of often a hollow threat too. It's just not
Mm,
practical. And the other thing is, people want to be fair and reasonable to one another, and they come to their own agreements with the idea of knowing what's going on. But let's just talk about the collaborative process. So this is where interest-based negotiation comes into play, and this is really important. So it's a bit of mumbo jumbo to call it interest-based negotiation, but what we talk about is what's important to, the mom and dad about the kids, what's important to each of them about their relationship or about the future, what's important to them. We get those principles down, and that's where once you understand the principles, you can then work towards getting those concerns and issues dealt with. We then go over the issues. Sometimes they're pretty straightforward to figure it out. We then get the third phase is we just get the information, get the data, get the documents that are needed, if get a full understanding by both people of what the situation is. And often that's the biggest battle that people, when they're going to court, is they spend tens of thousands of dollars sorting out what happened or what things are worth or who has what. And collaboration is really much, much quicker and more effective of doing that. And then we'll come up with a whole series of choices for people and work with them, choices that work for them, choices that we, as experienced mediators, lawyers, and collaborative lawyers, have seen, to give people like a buffet of choices. And then they go through those, and most people come up with a solution that works, that meets all of their needs or most of their needs. And then we'll then draw the contracts and come to an agreement. But there's another key part to this, isn't there, Charmaine? And it's about bringing in other professionals and experts to assist in the collaborative process. Why don't you talk about that for a while?
This is huge. As much as I think it's nice to sometimes blow our own horn as lawyers, we actually are experts in the law, and we're not the right tool in the toolbox to help people with some of the other things that other professionals can. So by bringing in a collaborative family professional, for example, to help people work through their communication issues that they might have, some of those emotions that are very natural as you are working through the grieving process of transitioning into from being spouses into this new configuration. And if you have children, how you're going to manage the parenting. So bringing in somebody who can spend time with Robert and Jane specifically on that is a great, we call it, using the sharpest tool in the drawer because, or pencil in the drawer, I don't know, I always get those analogies mixed up. But the point being is that as much as Brad, you and I could say what the law has to say about parenting, there isn't anything specific in the law about communication or actually how to do the parenting effectively. And likewise with a financial professional. So bringing in a neutral person who has knowledge and expertise about things like tax consequences, able to do projections into the future around those options that might be generated on how to divide property and how to manage cash flow by reference to the spousal support guidelines, if there's spousal support, by reference to federal child support guidelines, if there are children involved. All of these extra pieces that are added value within this process. So you're not just relying on the legal advice.
We lawyers and collaborative lawyers especially, we've got specialized training about negotiation, and sometimes the finances are pretty straightforward, and sometimes they're complicated for a whole bunch of different reasons. The dynamics can be simple, they can be complicated. We're also in a position where we can draw in other experts, such as, well, my most common one's a real estate appraiser, where you can share in the cost and you come up with one person to come up with value. And through a collaborative process, essentially it saves money for everyone and saves time by doing those things. And there can often be other professionals in addition to the collaborative financial professional who can get involved in some cases. And they're also bound by this principle that they're not going to be brought into any litigation at a later date. It's possible the couple could agree to use their information, but it's not going to be the subject of any court. We go to paragraph 4, which is cautions and limitations. Well, we're lawyers, so we have to make some cautions and limitations. Can't make a guarantee as to what's happening. And we're there for dealing with practical issues, dealing with parenting, property, and financial support, because that's what the law talks about. We're not marriage counselors. We can't give personal counseling to people, although I think as a collaborative lawyers, we're very sensitive to people's needs in those fields, in those areas, and cognizant of changes we may need to make to a process. That's really where you bring in either a collaborative professional or people have their own counselors to help them get through this life transition. And as part of this, you're giving up some legal remedies, at least while you're in the collaborative process. If you go outside of it, There's a whole rigmarole of things you have to do to have a judge make a decision. While you're in the collaborative process, you're not going to courts. You're giving those things up. Um, and, those are some of the trade-offs that you make. However, in a collaborative process, we ensure or do our best to ensure that you have all of the information, all of the documents and the like that are needed. And we go from
The-
there. But let's talk about the children. Why don't you talk about how children are dealt with in the collaborative agreement?
Well, when people have children, whether those children are still minors or they're adults, the process of going through a separation and divorce can impact the children. And generally, we find that most people are wanting to prioritize their children and minimize the negative impact a separation process could have on them. So, this section is very important as a reminder, is that we agree to make every effort to reach solutions that promote the children's best interests and to promote a caring, loving, and involved relationship between the children and each parent. So we're acknowledging that conflict between parents can be harmful to children, and that one of the commitments is to refrain from criticizing each other either in front of the children or even in a space where the children would potentially hear that. So always be thinking the best about the other parent and speaking that as well. Supporting the other parent's relationship with the children, not putting the children in the middle for the sake of passing messages back and forth. And that if there is going to be communication with the children, it will only by way of through advice, maybe the family professional who's involved. We might have a child specialist on the file, depending on the needs of the family.
And I just point out that most people don't consciously decide to put their kids in the middle, and they don't consciously to do behaviors that might harm the children or make the children feel they have to line up behind a parent. A lot of that happens at an unconscious level or at a good faith level. And just the uncertainty of the situation harms children. Even if both parents are behaving their best, the children really are worried and afraid about what's going to happen. They don't know if they've got a house. They don't know what school they're going to go to.
Mhm.
They don't know if they'll have a relationship with mom and with dad or with, both parents. So you end up in a situation where the children, because we're in a situation, we can talk candidly about those things, get the assistance that's needed and move forward. So I think that's a very important part. It's what you're supposed to do. It's what everyone wants to do. This is actually a process where you're able to do it. So
Yeah,
let's just talk about the
absolutely.
end of the collaborative process, and I'll just quickly walk through this.
Mhm.
At the end of the day, again, this is one of those things that if the collaborative system isn't working, you can say, listen, I want to try something else. But what often people will say, well, let's go in front of a judge, not really having a good idea of what's going to happen. But if that happens, then we end our involvement. People have to give 30 days notice of court. That just prevents people from acting rashly. And anything that we had in the collaborative process is confidential and can't be used in a court process. But that's the same rule that applies to any kind of negotiation. You can't bring it to court. And we facilitate a transfer of the file or of letting the clients know what to do next. And people can move on and they come away much better educated with a much better level of understanding. So even if the collaborative process works, they're usually better off by knowing they've done what they can to settle. And then we have
And
clause 7, which again, this is part of the legal side of things,
mhm.
that the agreements that we do here in this middle process where we haven't reached a final settlement are generally interim or tentative agreements that aren't necessarily, if you walk away, legally enforceable. They may be, but there are ways to make things binding. But often we ask people to ask in good faith about making payments, about time with kids and all that stuff, and we build through it. But
It's how they it's how they build trust, because often at the beginning of a separation there has been some damaged trust, and having a series of interim agreements between meetings helps to build that trust as you're working towards your final and binding agreement. Then the last couple of pieces here are with respect to the fees. So each party is responsible for their own lawyer's fees because, of course, we represent each other. Or sorry, we each client has their own lawyer. So we're just making that clear. And you are, by signing the agreement, acknowledging that you've read the contract, you understand its content, and agree to its terms, which is why we wanted to make a video so that you had an opportunity to be able to look through the contract in advance of the joint meeting where we'll be looking at it all together.
And we do have a schedule. We'll talk about this on a separate video about just how you can be effective in a collaborative process. And it's got some pretty basic things. And I think people know these things in their hearts, but it's just not natural. So we'll talk about communication and how people can work together better as part of another video. And it's part of what the magic of the collaborative process is that people um, once they get past their initial upset, they often have problems communicating, that you can start a
Mhm.
communication process. And once communication starts, settlement usually follows. Well, thank you,
That
Charmaine.
is true.
And we will
Yeah.
be talking again. And I look forward to working with you on many more collaborative cases. Any final comments before we wrap up here?
No, if you're watching this video, I think it probably means that you've either committed to the collaborative process or you're exploring it. And so we would just encourage you, if you have questions, to reach out. You can find me through our website, commonsenselawyer.com, and Brad, you're at
Settle Now
settlenow.ca
Online.
or .com.
Settlenow.online. And I'll post
There
the
we go.
notes below with our phone numbers, our websites, and
Perfect.
emails so people can contact us. Thanks very much, Charmaine.
Awesome.
I
Thank
enjoyed
you.
this. Bye bye.